Hi, this is Trevor Cutmore. Thank you so much for coming on to see this video. I'm doing a series of interviews with great professional people who've got great insights, and the whole point is to help you, property investors, overcome barriers and obstacles to help you complete that deal. Now, I've got a lot of experience, but if I'm just talking at a camera, it doesn't really work. So I love talking with people. I learn, they learn, and more importantly, you learn. So listen, if you like this video, please like it, make a comment, and if you can share it, that'd be fantastic. I wish you all the best. Hi, it's Trevor Cutmore here. Listen, it is a privilege to interview Sam Hawking from Sam Hawking Solicitors, and he is a specialist solicitor. He does everything, but he specialises in a lot of other contracts. He's doing some joint venture work for me at the minute to set contracts up, and he is a lease options specialist. So we're going to talk about lease options, and I've got Sam here to give us some good insight. Is that okay, Sam?
That's great, thank you, Trevor.
Great. So listen, with lease option agreements, when people really don't know what they are, a lot of people will say they're not very secure. I don't really understand. I know that you can get control over the property, you don't own it, and then you can use it. And look, you know that a small amount of information can be really dangerous for people. Would you agree?
Yeah.
Right. So look, if you were going to explain a lease option agreement to a layman, how would you explain it? And how secure is it?
And how secure is it? Well, how would I explain it first of all? Well, a lease option is basically a lease. Most people have an idea of what a lease is.
Yeah.
In a simple form, it's the same as renting a house.
It is.
To some extent. I agree. And albeit it's normally on a commercial basis, but they normally understand what a tenancy agreement is, and bolted on to that is an option agreement giving the investor or the person that's taking on the lease option the right to buy that property over a period of time. The buyer doesn't have an obligation, but the seller does have an obligation to sell if the buyer wants to.
And that's the powerful thing, isn't it?
Yes, it's a powerful thing, but from a seller's perspective, they don't have certainty.
No.
And if certainty is important for them, then lease option isn't for them. What is certain is the lease, is the obligation to pay whatever that obligation is, whether it's a rent, whether it's to cover the mortgage payments, or whatever the obligations that are agreed for that lease, subject to there being any break clauses. Then the seller has certainty for that part of it, but not for the actual sale.
Yeah.
In terms of how secure is it? Well, from the seller's perspective, how secure is it? Well, it's a contract, and the same with any contract. It's only as good as the wealth of the person that you're entering into a contract with. In other words, if the investor doesn't do their part in the deal, the owner might want to sue them, and you only sue someone. The general principle is you only sue someone if they've got the money to pay to court, to pay to you what you're suing them for. There's no point suing someone for £50,000 if they've got £1 in the bank account.
I understand that well. From
the investor's point of view, how secure is the deal? When you enter into a lease option, if the lease is less than 7 years, it doesn't need to be registered. It's what we call an overriding interest.
Fine.
If it's for more than 7 years, it must be registered at Land Registry. Fine. And it's as secure as the terms within the agreement, and it's as secure as you must obviously keep your side of the bargain. You must keep the terms and conditions of the agreement, and if you do that, then the owner can't get rid of you.
Yes. He's
made a commitment to you for that time. How secure is your option agreement? The option part of the lease option. The option must be registered at Land Registry, and the way that we do that is with a notice.
Yes.
So that the whole world, the law considers that the whole world will know about your option.
Yes.
Of course, they can only find out if they actually download the title.
Yes.
But that's what it means in law. And so if the owner was to somehow sell to someone else, or somebody else takes an interest in the property, they're considered to know about your option and are subject to your option. So for argument's sake, if the owner was to sell to a third party and they couldn't claim they weren't aware of your option, because it's noted in the title, and they would be and the new owner would be obliged to sell to you for the option price, whatever that may be. And if the option price is less than they paid, then that's their problem. But of course, the other thing that we would normally do to protect a lease option would be to enter a restriction in the title,
right,
which prevents the owner from selling, leasing, mortgaging the property without the lease option holder's permission.
That's right.
And sometimes, for instance, remortgaging is most appropriate.
Yes.
If the mortgage deal comes to an end, and you need to.
So we're just not about 20 minutes. That's right.
Yeah.
That's right. So where are we? Okay.
If the lease option, what was I saying? If the lease option comes to an end, protecting it with a notice.
Yeah. Just go from there.
So to protect we protect the lease option with a notice, but we can also protect it with a restriction.
Yeah.
The restriction stops the owner of the property selling, mortgaging, or leasing the property to anybody else without your permission. You only give your permission if it's in your interest to do that, or if it doesn't affect you or your right over the property. And sometimes it's wholly appropriate to for instance, to mortgage if the owner's mortgage comes to an end, or if the owner's special deal comes to an end and it reverts to standard variable rate, and the interest rates go up a lot. Obviously, if the investor's paying the mortgage, they very much want the interest rate to come down and a refinance to take place. But just looking after the other party in the deal would mean that you may want to agree to a remortgage. And you can do that, but it's important that the investor understands that they don't want the owner to get into negative equity.
Yeah,
so if the owner's borrowing more money, is the outstanding balance, is everything that's owed less than what you're paying? And of course, if the owner is paying their own mortgage, you don't want them to be in a position where they don't pay the mortgage for a while and then they get into negative equity. You want to make sure that there's a margin for your own comfort.
Yeah, no, definitely. And what about how important it is if someone's got a potential lease option?
Yeah.
And I'm going to ask you what information you want, because I'm sure we all do it. We all come up with limited information. You say, can you give us this information? So we'll talk a little bit about that. Yeah. But let's supposing that someone, they're getting a lease option. How important is it for them to go off and look at that individual, the mortgage holder's credit? Because there might be a lot of debt involved.
Yeah.
How important, and how should they do that?
Okay, well, it's very important that they look at the amount of debt on the property.
Yeah.
It's not such a big issue if the owner has a lot of bad credit,
right?
Because you're not lending money from them.
Yep.
You're not expecting them to pay you. What you're doing is paying them some money and relying on the fact that you're going to be in a position to exercise your option on the property in the future, whenever that date is, or whenever that time period is that you've got, whether it's a year or 10 years.
Right.
What you want to know is the current debt, so the current mortgage company, assuming there is one, is not going to be repossessing that property in that time frame, and that there's enough equity in there that if something does go wrong, that you can take action.
Look, with an option deal, a lot of people will, when people go on courses, and I'm training people on how to do lease option agreements. When they think they potentially got one, and they ring you up and say, Sam, look, I need help, I want this option deal. You don't want everyone coming up and giving you, look, here it is, because it's not your deal. You want to help do the legal side of them. So what's probably the classic thing that people miss? What's the sort of 4 or 5 things that people miss, and you think, you know, you never say it because you're very polite, you're a gentleman, you really are, Sam, but I'm sure inside you actually look at people with that big smile on your face and you think, oh my goodness, please get the basic information.
Yeah.
So what do they classically miss and they should get?
Well, really what they need to have is a template heads of terms that they follow, that they go through. They don't have to use the template verbatim to negotiate a deal, but they need to consider every point on a comprehensive heads of terms template, and consider, do I need to, for instance, typically on a lease option template, you'd have a lot of information about the mortgage. If they haven't got a mortgage, you're only going to deal with the first one. You know, is there a mortgage? If there is a mortgage, you need to drill down and understand who the mortgage lenders are. Is there just one? Is there more than one? Who they are? How much is owed? What the terms of those mortgages are? It's no good having a lease option for 10 years if the mortgage is up in 2 years' time. You're barking up the wrong tree. So most people that don't have a comprehensive heads of terms template will skip over or even ignore the maintenance of the property. And the maintenance of the property is massive. And in commercial agreements, what we call dilapidations in commercial work is a massive thing for businesses, and very often a rent-to-rent agreement is a business agreement. And so getting the maintenance and the condition of the property and the dilapidations responsibilities wrong can mean fully refurbishing a property because it's not in great condition. It might be in the same condition it was in when you took it on. It might even be better. But for instance, if your agreement says you've got to maintain and repair the property, it means just that. And if it's not handed back in pristine condition, that's got a price tag attached to it.
I agree, and that's one of the key ones which people tend to miss.
Yes.
Right. Yeah. Is there another big glaring one out there that people miss? I mean, sometimes the name of the owner or something. I don't know.
They've normally got the name of the owner. Right. Yes. I mean, typically, people will not appreciate that lease options is a niche area of property law. And it's very common in commercial property. And so if so a lot of investors will come to us and say, I've got a deal and here's their solicitor, and they haven't actually considered whether the owner hasn't considered whether their solicitor is experienced in dealing with these kind of arrangements. If they've got a good relationship with a commercial lawyer, then that's perfect.
Right.
But typically they'll be charging quite high fees.
I agree.
And that there is a small number of firms that are used to dealing with these kind of agreements on residential property in frequently, sort of in bulk, if you like, and offer very competitive fees for this kind of work.
Excellent.
I think that some investors are a little bit taken back, though, that the fees are a little bit more than standard conveyancing.
It's a specialist area.
It's a specialist area, and there's more hours need to be spent by a qualified person going through the agreements.
And this is more contract law.
Yes.
It is, and that is very specific. Look, there are large companies. I remember hearing one that because a word was in the wrong place, the company lost £250 million. And there is a lady that I was talking to recently, and she's doing Sellafield, and it's over £1 billion contracts, and the lawyers and the barristers are going through those contracts. So imagine what the costs are. But it's so important that the contract is right, and grammatically everything has to be in place. So this isn't just your normal conveyancing, and that's why it's important.
Frequently, if a high street conveyancer picks up a lease option, they won't like what they're seeing. They don't understand how to necessarily advise on the risk because they're not familiar with it. and
Well, can I, sorry, Tom. Let me just say. Look, I have a solicitor that I use for all my conveyancing. It's because I've had long-standing track record with him and everything. So that's what I was doing. But I said to him, look, I'm doing this joint venture and going to start doing some more development stuff. But I need this joint venture, and he said, Trevor, I don't do joint venture, so that's it, Sam. That's it.
Yeah.
And that's the importance, isn't it? Going to the right solicitor. But at least my solicitor turned around and said, look, I don't do it.
Yeah.
But that's if the other side used him and said, can you look at it? Hopefully he said, I'm not specialised. He wouldn't look at it and say, oh no, don't do it. He'd just say, I haven't got the skills to advise you. Hopefully, because many actually say, no, this is rubbish, because they don't understand.
Yeah. Well, obviously within our firm we have several solicitors that specialise in each different part of property deals. We don't do anything outside of property work.
Yep.
And if it's outside of property work, we'll always try and give some high level guidance, and then signpost someone to another firm that has speciality in that area.
How can people get the heads of terms? Is it on your website?
It's not on a website, but happy to give them freely to anyone that asks.
Well, if you can send it to me, I'll put it on my Facebook.
Yeah.
And I'll put a link to your website on this talk anyway.
Yeah.
So it'll drive people to you, because obviously I highly recommend you, and it's great.
Thank you.
Look, let's just talk a little bit with an option deal. We talk about security and everything. What about if you're running a property and things change in your own and you don't want to complete it for whatever reason? I think there's very few that don't want to. How easy for it to get out? Because some people think, I just don't have to do anything, I can walk away from it, which you can't.
No. If the lease is going well, in other words, you've got it let out, you've got the money coming in, but perhaps the price hasn't gone up like you thought it might, and so it's not a particularly favourable price on the option, even though time has passed. You wouldn't want to exercise the option for the option price. So, but there's a couple of things there. First of all, you don't have to use the option to buy the property. You can just negotiate. You could say to the seller, look, I've got an option for 200,000. At the time we took the option out, it was only worth 180, and perhaps the property market's dipped, and now I think it's only worth 170. I would like to buy it, but I'm only prepared to pay 160 or 170 for it.
Yeah.
Do you want to sell it? It's come towards the end of our deal.
Perfect.
Do you want to sell it to me for that price? And basically we'll just tear up the option agreement.
Perfect.
So that's an option. However, so we do get clients come to us. They have been in the option agreement, for the lease option, for a while. It's not working very well for them, and they want to get out. Now, if you've entered into a deal for 10 years and you don't have a clause in it that allows you to get out, then you are tied in for 10 years.
Yeah.
And if it's not assignable, then you are tied in for 10 years. If it's assignable, then you could try and find someone else to take your place
and sell that option
and sell it on, or just give it away if you really don't want it.
Yeah.
We did have I was advising a client day before yesterday. They entered into a lease option. In fact, it wasn't a lease option, rent to rent, which is basically the same, just with an option bolted on, or without the option bolted on.
Yeah, without it, yeah.
So they entered into a rent to rent. They're going to use it as serviced accommodation just before Christmas, and they didn't have legal representation when they entered into it. Yes. The checks were not carried out in terms of what the use can be. And then she's come to me saying, look, the agents have said that they're taking the lease away from her. And it's a 5-year agreement. She's only just started letting it with service accommodation. She spent quite a lot of money tidying it up, decorating it, fully furnishing it to quite a luxurious standard. And she's done it with 2 flats in the block. And now to be told that her lease has been taken away from her is quite upsetting.
Is that because the vendor didn't have legal representation?
Well, it's 2 sides to it, because she didn't know where she stood, and neither does the seller. In actual fact, there is no clause in her agreement to say what it can be used or can't be used for.
Right.
So they can't
ambiguous.
take it's ambiguous. So from the seller's perspective, it's unsatisfactory.
Yes.
And however, it does say in there that you can't breach the terms of any covenants on the title.
Yes.
And so what we're now doing is obtaining a copy of the title to see what the covenants are, to see if the actual lease title has a covenant to say what it can and can't be used for.
Yeah.
And that may mean that she can't use it for serviced accommodation. Yeah. She may want to give it up after we've advised her. On the other hand, we may be advising her that the seller can't force you to give it up.
Yeah.
It's very messy.
Yeah.
When proper advice isn't sought.
Can I say this really is gold dust for you guys. Look, a service accommodation. A lot of people, look, that is the flavour of the month or the year or this season right now. And a lot of people want to do options, especially on apartments, and rent them out short term on a service accommodation. So any apartment, most apartments, unless it's a share of the freehold, will come with a lease, normally 99 years, 125, and that rolls down. Now, on that lease, there's a head lease which tells people what they can and can't do on that property. Please correct me if I'm wrong.
No,
all right.
Go ahead.
And quite often, in that head lease, it will say no commercial business or commercial activities can take place on these premises. That means service accommodation cannot take place on these premises because service accommodation is a business. Okay, correct?
Yes, I mean you can argue the point because service accommodation is sleeping accommodation, and some, depending on the wording, it can say something along those lines. But even then, there'll be a separate clause that says that you mustn't breach the terms of the insurance policy.
Yeah.
And even if you can argue the case with your landlord, if the whole block of flats burns down, you're not going to get very far arguing with an insurance company who says, I'm not paying out £5 million to rebuild a block of flats.
Yes.
And to try and I'm not aware of a sort of a separate policy that you can take out to protect against that. And if you do approach the buildings insurers for a bolt-on policy, I expect that the additional premium for the whole block would fall on fall to the person that wants to do serviced accommodation. And because it's insuring the whole block for that additional risk, I would expect it would be quite a lot of money.
No, and obviously the reason behind it, the practical reason, is that you've got multiple different people coming in for short term, and you don't know what those people are like, or they're not referenced really. I know there's a referencing system, but they're not as deeply referenced as a 6 months tenancy agreement. So this is the issue. So for any investor, go and get a copy of the head lease and have a look at it, because if it's saying these things and the insurance policy, then you are flogging a dead horse. And I would suggest that any option agreement could be broken subject to those terms.
Yes.
Or strongly argued against, and you've got a problem.
Yes. Yeah. When entering into a rent-to-rent agreement, for instance, it's not so important to have legal advice. However, it's still a commercial agreement.
Yes.
And if you enter into the wrong terms, you're bound by those wrong terms, unless you can negotiate out of them. With an option agreement bolted on, then there is much more risk, especially where it's on residential property. There's much more risk that the seller will be able to say you didn't understand the terms, it was an unfair agreement, and get out of the deal.
Brilliant. Look, just one more really thing I'd like to talk about in brief, really, and that's assisted sale by adding value to a property. So let's suppose you're going to put £50,000, a significant amount of money. Give you a scenario so it's easy for everyone to understand. Let's suppose there's a house, it's £500,000. I've offered them £425 to buy, and they said no, we need to make more money. But I see that there's potential, and I say, well, look, if you want 500, if you give me time, I will invest £50,000 by doing a small loft room, redoing the whole house. Now let's suppose we sell it $650, so we've made, let's say, £90,000 profit after all the other costs. And I can give them their 500, I get my 50 back, there's £90,000 which I can split with them either way, 50% or 80% or all mine, whatever.
Yeah.
So, but that's a scenario. So I'm putting £50,000 of my own money in.
Yeah.
How secure is that for me? And you know, how do I stop them once I've done it? How do I make sure they say, "Oh, thank you very much, we like that, we want to stay here"?
Yeah. So, first of all, you can't really stop them from staying there, and a court is highly unlikely to make them move so long as they pay you. Yeah. If they pay you your money and your profit out, then they will be able to stay there. But that actually is good for you, because it means you've got a buyer immediately, so long as they come up with the money in a timely fashion, of course.
Okay.
But so when you want to enter into this kind of deal, the first thing you need.
So when you say buy, you're basically saying the judge would say, look, okay, you don't have to leave, but you have to pay Trevor the increased value that he's created and his money back.
Yes.
So they need to satisfy that option.
Whatever Trevor was due.
Yes.
Assuming it was sold to a third-party buyer in accordance with the agreement that you've reached, then so long as you pay Trevor his money,
you can stay.
Then you can stay.
And they put a time level on there and allow them to work that through.
Yes.
Perfect.
Yeah. That courts are normally fairly sympathetic towards homeowners.
Yes.
And rightly so.
Mm-hmm.
And I would expect the court to give them time to do that.
Perfect.
So long as they appear reasonable and genuine in what they're trying to do. So when you get into this situation of you've found a potential assisted sale, then it's the same thing as before. The first thing we would want to see is heads of terms.
Yes.
We would then draw up an agreement that clearly sets out what you're agreeing and binds both parties to those heads of terms. We would protect your agreement by way of a notice and a restriction, so that everyone, the whole world, is considered to know that you have an interest in the property, and so that they can't sell to a third party without your consent, or increase the mortgage so that there's no equity in it any longer for you. So you're protected there. If they're still living in the property and the exit is to sell, you've then got to get them out. And of course, there is a higher risk in that case that they're not going to move out because they like what you've done. Yes. If they're not living in there, the risk of them wanting to move in there is of course lower, and that should give you a little more comfort. But even if what you're relying on is them honouring their contract, of course they're relying on you honouring your side of the contract as well. Yes. If you're carrying out work to their property, you said £500,000 worth of property, are they really going to let you into their property with a sledgehammer? Yeah. And no, so there has to be a lot of trust between each party, and sometimes there needs to be some sort of financial bond to give the confidence in one another that you are actually going to carry out your side of the agreement. And sometimes there's other ways that you can provide confidence to the other party that you are actually going to honour your part of the agreement, so that each party gets the exit that they want. Perfect.
Thank you so much again for watching this video. I hope you got a lot of information and it's helped you on your journey. If you have liked it, please like, subscribe and share to help other people. I wish you all the best. Thank you. Bye bye.